defense as to the facts of the case as well. And I've reviewed the psychiatric reports again. The defendant had been found to be not only competent but also sane. And Mr. Kersey, thank you for bringing that again to the court's attention, because I had looked at that for any litigation that was involved there as well. I've reviewed 2929.11 for the principles and purposes of sentencing, 2929.12 for the seriousness and recidivism factors, and 2929.13 and other revised code sections for felony sentencing. I've also reviewed 2929.21 for the misdemeanor sentence, the domestic violence that you pled guilty to as well. And the court has formulated the following decision based upon those overriding principles and purposes of felony sentencing, which are to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. And I have considered the relevant sentencing guidelines provided, again, in revised codes 2929.11, 2929.12, 2929.13 through 2929.19. And looking at your pre-sentence investigation, sir, the court will note the Ohio Risk Assessment Summary, your recidivism risk level. You have 2 high scores in education, employment, finance, as well as substance abuse. A medium score in family, social support. A lower score in criminal attitudes and peers. The facts of this case they are horrific. I can't imagine the hurt and the pain that family members and friends are going through who knew this person. By all accounts, somebody who was faithful and loving and had a 35-year commitment to you and to her family, a daughter that loves her very much and searched for her, and must be very conflicted. But I truly appreciate the pain and the suffering that she and others are likely to go through, including your own grandchild that won't get to know her because of your actions. I don't know all what did happen, sir, but it is very clear that if it hadn't been for your anger, she would not be dead. She'd be here with us. For this felony of the first degree involuntary manslaughter, sir, the court is giving you the maximum time of 11 years on the minimum side of the indefinite sentence. As we discussed before, your maximum side on that count alone will be determined by that sentence, which is 1/2, or in other words, 50% of that 11-year sentence, 5.5 years. So on that count alone, you're to receive an 11 to 16.5-year sentence. As to the offenses against the human corpse, commonly known as abuse of a corpse, felony of the 5th degree, the court will give you a sentence of 12 months on that. And as to the tampering with evidence, 2921.112, or the harm caused here on this, and your very callous disregard of the sanctity here of life and this body of somebody that you say that you loved. the court is giving you the maximum sentence there, 36 months. I'm going to run the abuse of a corpse concurrent, that 12-month sentence with the involuntary manslaughter and the tampering with evidence charges. The domestic violence charge, misdemeanor of the first degree by law, will be run concurrent with all the sentences. That will be a 180-day sentence on that. As to that offense of tampering with evidence, a felony of the third degree, the court is finding that that is a consecutive sentence. You must serve that sentence consecutively to the involuntary manslaughter sentence, sir. I've reviewed Revised Code 2929.14C4B, and the court makes the following finding. The court imposes prison terms consecutively, finding that the consecutive service is necessary to protect the public from future crime or to punish the defendant. That the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger the defendant poses to the public, and that at least two of the multiple offenses were committed in this case as part of one or more courses of conduct, and that the harm caused by said multiple offenses was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the defendant's conduct. And that truly is the case here for you, sir, because not only did you commit this homicide, but over a period of days and, in fact, weeks, you set out to hide the fact that you did do it. You tampered with the evidence, which could have shed more light on this and what, in fact, actually did happen. Could have shed more light for your family, the daughter, the community, but also to law enforcement. We have nothing to go on but your word, and I'm taking you as your word. I'm using that as mitigation in this, and I'm finding that the abuse of courts will be run concurrently, sir. But you certainly deserve this sentence consecutively, and that will be a sentence then of 3 years consecutive to that 11-year sentence, so that's 14 years, plus the 5.5 years as 1/2 or 50% of that 11 years. So you were looking at a 14 to 19.5 year sentence, sir, that you could be sentenced to. As to your post-release control, when you are released for this felony of the first degree, there's a mandatory minimum of 2 years up to a maximum of 5 years that you will be supervised by the adult parole authority. And for that felony of the third degree, tampering with evidence, and the offenses against the human corpse, felony of the fifth degree, the adult parole authority could supervise you for a period of up to 2 years. It's at their discretion. As I read this to you at the time of your plea, I'll read it to you again. If you violate any post-release control rule or condition, you may be subjected to a more restrictive rule or condition, a longer duration under supervision, or you could be sent back to prison even though you've done all the time to which you have been sentenced. You could get up to 9 months in prison for each rule violation. The total, however, for all rule violations cannot be any more than 1/2 of the prison sentence that you receive, unless the rule violations were the commission of a new felony, in which case you could receive a prison term of the greater of 1 year, or the time remaining on post-release control, in addition to any time that you receive for the new felony. The post-release control prison term must be served consecutively to any prison term that you receive for the new felony. I don't think I've heard of a case, sir, where somebody has tampered with the evidence so many times. Had this been an offense that occurred perhaps all on one day, it would have been perhaps viewed differently in this court's eyes. But it does demean the seriousness of this offense if the court were to give anything different than this. I'm going to find you to be indigent at the request of your attorney, Mr. Kersey, and I will not levy any court costs or fines against you, sir. And I will give you the information that you do have a right to appeal your sentence. If you're unable to pay the cost of an appeal, you have the right to appeal without payment. If If you're unable to obtain counsel for an appeal, counsel will be appointed without cost. If you're unable to pay the cost of the documents necessary to appeal, such documents will be provided without cost, and you have a right to have a notice of appeal timely filed on your behalf. Is there anything further, Mr. True?
No, Your Honor, I think you've covered it.
Thank you very much. Mr. Kersey, anything